Hi, I'm Greg Sorensen, President for NAGE Local 282. With me is Richard Waring, who is our attorney, dedicated attorney here at NAGE, working with Unit 6 cases. And to my left, your right, is David Young, who is our national representative covering cases for this bargaining unit. David comes with an experience of many years working for the Commonwealth of Massachusetts as a high-level administrator, deputy commissioner in labor relations, working with these kinds of situations that we deal with at NAGE. The purpose of this video is it's a series that we will be making available for our stewards to go through each of the articles of the contract that we have with the Commonwealth. It's our intent to provide training and perspectives on the grievance process. Richard will be talking about the legal perspective. David will be talking from the perspective of the administration and what a good administrator would be doing in a situation under the particular article. I, of course, will be talking from the union's perspective on how we handle the particular grievances under each of the articles. So the format of this series is individual articles for viewing, probably on YouTube. The entire series is based on the premise of stewards interacting with our members and communicating with myself, with David, with our executive board. What I'm hoping is that that folks will use us here at NAGE to run different problems by us and ask for assistance, or at least bounce ideas off of us for solving problems. The more that we can do to prevent problems from getting any more formal, the better off we all are. So with that, I'd like to begin with looking at the preamble of the CBA, the Contract Bargaining Agreement. Very simply, the preamble brings to the contract the Mass General Law, Chapter 150E. And interestingly, what it says is to promote harmonious relations between the union and the employer. Harmonious relations, union and employer. And also the parties recognize the importance of dealing with one another with mutual respect and dignity. So that's the inherent intent of the contract, the entire contract. Mutual respect and harmonious relations in the workplace. And let me just start by asking David to approach this from the managers. What do managers look for? Or how do they treat the preamble of the contract?
Yeah, I would say in terms of the preamble, the primary goal of the collective bargaining agreement is to bring stability to the workplace. And that's a thread that runs through all the various provisions of the contract. Management is to administer the agreement in good faith, and the union is to enforce the agreement in good faith. Management and the union are to respect their obligations and responsibilities under the agreement. Problem solving and dispute resolution are mutual to both management and the union, as Greg has said. Management representatives undermine these principles when they say such things as, "The union has filed a grievance against me," personalizing it. Or, "Why did you contact the union?" Well, it's the employee's right to contact the union. This is business, not personal. This is a bilateral relationship where management and union are equal partners. Union representatives undermine these principles when they do not understand management rights and that the grievance procedure is to enforce the provisions of the collective bargaining agreement rather than as a weapon against management. A settlement of a dispute is almost always preferable to an intractable adversarial relationship. At all times, both management and the union should treat one another professionally in a bilateral relationship as equal partners under the contract. This, however, does not give management the license to be unfair or unjust in its treatment of employees. In those cases, it is helpful to cite the preamble in a grievance where harmonious relations are breached or management is not proceeding with respect and dignity in the administration of the agreement and its treatment of employees. Even if the preamble is not necessarily enforceable as such, it sends a message about management being in the wrong by undermining the harmonious relations between the union and employer and destabilizing the workplace.
Now, from a legal perspective, the bottom line to all of this in terms of enforceability rests within the law. And Richard, how do you view the preamble and enforceability?
Well, thank you. David has summed up the preamble really very well. I'll just add a couple of comments to what he had to say to flesh out what we believe the preamble really does. The preamble is really an example of what lawyers like to call hortatory language, which means it encourages the parties to do something, in this case, work together with mutual respect and dignity, but doesn't have any really specific requirements. That is, it's not like other articles of the contract that might specify something like the work week shall be 37.5 hours spread over 5 days. That's the kind of thing that would be specifically enforceable. But rather, the preamble, important as it is, really is a vehicle that encourages the employer and the union to work together in a cooperative spirit to solve problems in a harmonious and mutually respectful way.
Thank you.